Welcome to meeting number 99 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on February 15, 2014, the committee's meeting in public to study the subject matter of the supplementary estimates 2023-2024 under the Department of Justice. Today's meeting is taking place in a hybrid format. Members are attending in person in the room and remotely using the Zoom application. Witnesses are all attending in person today. The members attending by video conference have been tested and are aware of our procedure, including interpretation, so I won't go through those lengthy explanation this morning. So I want to inform the members that we're studying the subject matter of the supplementary estimates for the first 1 hour, and there will be no votes on the items. So I want to welcome today with us the Honorable Arif Virani, Minister of Justice and Solicitor General of Canada. It's not Solicitor General. Solicitor General was back in the 1980s. And the reason I know that, I was in high school and I participated in the very first model parliament. And I was elected, I don't remember if it was a nomination or an election, as the Solicitor General. And that was towards the time when, after that, they deleted Solicitor General from the books. So welcome, Attorney General.
And Mr. Virani was already a member of the parliament at that time?
No, I'm not even sure he was born.
Oh, yeah.
Also, with Minister Virani, we have officials assisting us today. Thank you for being here. Shaleen Curtis-Micallef, sous-ministre et sous-procureur général du Canada. Michael Souza, sous-ministre adjoint.
Michael Souza, Senior Assistant Deputy Minister, Policy Sector. Bill Kroll, Chief Financial Officer and Assistant Deputy Minister, Management Sector, and Elizabeth Hendy, Director General, Program Branch, Policy Sector.
With us, we will do the normal round of questioning, and I will call witnesses. Since the witnesses today are our own members, and most of you are here, I'm going to put the 30 seconds and the time is up so that we are very courteous and look after each other. Before we start, I have received the letter, and I just want to say, Minister, to you and your department, the letter was received from Nova Scotia Legal Aid thanking for the support of a project for supporting racialized inmates incarcerated in federal and provincial correctional institutions within Nova Scotia. So I just wanted to put that on record and say thank you on behalf of Nova Scotia Legal Aid. We will now begin with Mr. Van Popta for 6 minutes. Hold on. Oh, yes. Minister, you're ready to make a statement first, so please proceed. Thank you. That's why I have such capable team beside me. Merci, Monsieur le Greffier.
Merci, Madame la Présidente, les membres du...
Thank you, Madam Chair and members of the committee. Thank you for inviting me to join you today. I'll begin by recognizing that we are meeting on the traditional unceded territory of the Algonquin and Anishinaabe Nation. As you have seen, a few weeks ago I presented Bill C-63, the Online Harms Act. I want to both explain the vital importance of the Online Harms Act and dispel misunderstandings about what it does and does not do. The premise of this legislation is simple. We all expect to be safe in our homes, neighborhoods, and communities. We should be able to expect the same kind of security in our online communities. We need to address the online harms that threaten us and especially threaten our children every day. Let me start by talking about our children.
No safety standards mandated for the online platforms kids use every day. In contrast, my children's Lego in our basement is subject to rigorous safety standards and testing before my two boys get their hands on it. I know that these days, my children spend much more time online than playing with their Lego. The most dangerous toy in my home right now and in every Canadian home, are the screens our children are on. Social media is everywhere. It brings unchecked dangers and horrific content. This, frankly, terrifies me. We need to make the internet safe for our young people around the country. As a parent, one of the first things we teach all of our kids is how to cross the road. We tell them to wait for the green light. We tell them to look in both directions. We trust our children, but we also have faith that there are rules of the road and that the drivers will respect the rules of the road. We trust that cars will stop at a red light and obey the speed limit. Safety depends on a basic network of trust. This is exactly what we are lacking desperately in the digital world. The Online Harms Act establishes rules of the road for platforms so that we can teach our kids to be safe online with the knowledge that platforms are doing their part also. Maintenant, parlons des crimes haineux.
Now let's talk about hate crimes. The total number of police-reported hate crimes in Canada has reached its highest level on record, nearly doubling the rate recorded in the year 2019.
Across the country are calling this increase staggering, quote unquote. Toronto Police Chief Myron Demkiw said this week that hate crime calls in his city of Toronto have increased by 93% since last October. Communities and law enforcement have been calling on governments to act. C-63 creates a new standalone hate crime to make sure that hate crimes are properly prosecuted and identified. Under our current legal system, hate motivation for a crime is only considered as an afterthought at the sentencing stage. It is not part of the offense-laying provision itself. The threshold for criminal hatred is high. Comments that offend, humiliate, insult do not hit the standard of hatred. They are what we call awful but lawful. The definition of hate that we are embedding in the criminal code comes straight from the Supreme Court of Canada in Keegstra and in the Whatcott decisions. We did not make up the definition of hatred we are proposing. It has been disappointing, though not surprising, to see the wildly inaccurate assertions made by some commentators about how sentencing for this new hate crime provision would work. I've heard some claim under this provision that someone who commits an offence under the National Parks Act would now be subject to a life sentence. That is simply false. In Canada, judges impose sentences following sentencing ranges established through past decisions. Judges are required by law, and every member of this committee who is a lawyer will know this, to impose sentences that are proportionate to the offence committed. In other words, the punishment must always fit the crime. If judges impose a sentence that is unfit, we have appeal courts that can overturn those sentences. So you may be asking, well, why not specify that, Minister? Why put a maximum sentence of life in the new hate crimes offence-laying provision? Well, let me explain. First, it's important to remember that a maximum sentence is not an average sentence. It's an absolute ceiling. Second, the new hate crime offence captures any existing offence if it was hate-motivated. That can run the gamut from a hate-motivated theft all the way to a hate-motivated attempt murder. The sentencing range, entrenched in C-63, was designed to mirror the existing sentencing options for all of these potential underlying offences, from the most minor to the most serious offences on the books, such as attempt murder, which can attract, right now, a life sentence. Cela ne signifie pas que les infractions.
This does not mean that minor sentences will suddenly receive extremely harsh sentences. This would violate all the legal principles that sentencing judges are required to follow. Hate-motivated murder will result in a life sentence. A minor infraction will certainly not result in it. Another criticism I have heard is that this bill could stifle freedom of expression. This is simply not true. On the contrary, this bill strengthens freedom of expression. There are people in Canada who cannot speak out because they legitimately fear for their safety. When they speak out, they are mistreated and subjected to truly despicable threats, intimidation, and harassment.
carefully balanced. We consulted, we looked abroad. We do not do an automatic takedown of material within 24 hours, except for child sexual abuse material or revenge pornography. We do not touch private communications. We do not affect individual websites that do not host user-generated content. Ce projet de loi protège les enfants et donne à chacun des outils dont ils ont.
This bill protects children and gives everyone the tools they need to protect themselves online. We do not tolerate hate speech in the public square. We must not tolerate hate speech online. We have seen the consequences of unchecked online hate and child sexual exploitation. Ask the families of the 6 people killed at the Quebec City Mosque by someone who was radicalized online.
Demandez aux jeunes garçons devenus orphelins à la suite de l'horrible attaque contre la famille Afzal à London, en Ontario. Demandez aux parents des jeunes qui se sont enlevés la vie après avoir été victimes de sextorsion par des prédateurs en ligne. Et enfin, permettez que je remette les pendules à l'heure en ce qui concerne la disposition relative à l'engagement de ne pas troubler l'ordre public. L'engagement de ne pas troubler l'ordre public n'est pas la détention à domicile, ce n'est pas une punition. Les engagements de ne pas troubler l'ordre public sont des outils bien établis, utilisés pour imposer des conditions personnalisées à une personne lorsqu'il existe des preuves crédibles qu'elle peut blesser quelqu'un en commettant un crime motivé par la haine. L'engagement de ne pas troubler l'ordre public proposé fonctionnerait de façon très semblable aux engagements de ne pas troubler l'ordre public existant. À titre d'exemple, si quelqu'un publie en ligne son intention de dégrader ou d'attaquer une synagogue pour intimider la communauté, les membres de la synagogue pourraient transmettre cette information à la police et au tribunal et demander l'imposition d'un engagement de ne pas troubler l'ordre public après avoir obtenu le consentement du procureur général de la province. Des décennies de jurisprudence nous enseignent que les conditions doivent être raisonnables liées à la menace spécifique. Ainsi, les conditions imposées à la personne pourraient inclure le fait de rester à 100 pieds de la synagogue pendant 12 mois. Si la personne ne respecte pas cette simple condition, elle pourrait être arrêtée. S'ils respectent leurs conditions, ils n'en subiront aucune conséquence. Si nous pouvons empêcher que
Wrong console. Guys? No, middle console's on too. Rising hate crime, our government believes that doing nothing in an instance like this would be irresponsible. And I think that's what explains both CIJA and the Special Envoy on Anti-Semitism's support of Bill C-63. Comme toujours, je suis ouvert aux suggestions.
As always, I'm open to good faith suggestions to improve this law. I'm intending to get it right. I look forward to debating the Online Harms Act in the House of Commons and following the committee's process as it reaches that stage. I'm convinced that we all have the same goal. We need to create a safe online world, especially for the most vulnerable members of our society, our children.
Happy to take your questions.
Si, thank you. On commence maintenant avec...
We will begin with our first turn. Mr. Van Cockton, 6 minutes.
Sharon, thank you, Mr. Attorney General, for being with us here today, and to all the rest of the witnesses. Mr. Attorney General, you're the top lawyer in the land, so it's good to have you here at the Justice Committee. Now, Canada is a rule of law nation, and we function well only if citizens of the nation have confidence in the administration of justice. That's your job. This is true for the criminal justice system as it is for the civil justice system. And that's why it's so shocking to hear from a credible organization like the BC branch of the Canadian Bar Association in a letter dated, now this is 4 years ago, to your address to your predecessor, Mr. Lametti. And this is what the CBA said. Our Supreme Court of British Columbia is presently 7 judges below complement. As a result, parties are regularly arriving at court for trials and hearings that are being sent away because of a lack of judges to hear the cases. The parties have spent substantial time and money preparing for court appearances. Witnesses have also been inconvenienced. And then it goes on to talk about the financial and the emotional cost. Now, there's an example from a lawyer, and you'll appreciate this, of course, being a lawyer yourself, that said, I've had this problem of delays several times, 5 times that